Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. I think we have one administrative matter. Is that correct?
Thank you, Your Honor. I'm before you this morning with a preliminary motion to swear in a new member to the bar of our court. Before making the motion, with your permission, I'll introduce the candidate. I'm delighted to introduce to you this morning Bob Neal, who is Judge Murphy's law clerk. He is a member of the bar of the state of Colorado. Like you, Judge Bacharach, and me, he is a graduate of the outstanding law school of Washington University in St. Louis. And before moving for the admission of Mr. Neal, are there any questions or comments?
None from me.
Are you in any way related to Betsy Shoemaker?
Indeed. Yes.
Okay, that's enough credential for me.
That was an important question.
It is a very important one.
I respectfully move for the admission of this candidate to the bar of the United States Court of Appeals for the 10th Circuit. May I administer the oath?
Please.
Would all members of the 10th Circuit bar please stand and silently renew your own oaths? Please raise your right hand and repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will conduct myself as an attorney and counselor of this court
that I will conduct myself as an attorney and counselor of this court
uprightly and according to law,
uprightly and according to law,
and that I will support the Constitution of the United States.
and I will support the Constitution of the United States.
Congratulations.
Would the inductee please step forward to the bench?
Uh-oh.
Congratulations, Steve. Well done.
Well, congratulations that you have a wonderful mentor. We have 4 cases. We may or may not take a break after 2 or 3 of these. The first case we'll hear is Harrison versus Envision Management Holding. It's 22-1098, and we'll hear from the appellant.
Good morning, Your Honors, and may it please the Court, Barbara Smith for appellants in this case. The question the Court faces today is whether there's an irreconcilable conflict between the Federal Arbitration Act on one hand and ERISA and the causes of action that ERISA provides on the other, such that this individual plaintiff cannot effectively vindicate his ERISA rights in individual arbitration. But because there is a way to read the 2 statutes consistently, this court can and should do that and should reverse to compel arbitration.
Counsel, can this plaintiff obtain the relief that he seeks if this arbitration agreement is enforced?
Well, the operative legal question is whether he can obtain effective relief, whether he can effectively vindicate his rights.
That would be plan-wide relief, wouldn't it?
It would be, in this case, his right to pursue individual monetary remedies. In other words, all of the monetary damages he claims to be due under the alleged breach of his individual plan account.
But he seeks wider relief, does he not?
He has pled wider relief, but the arbitration clause is limited to his individual monetary relief, and the operative legal question is whether providing him only that relief allows him to effectively vindicate his rights as ERISA has outlined them. Now, he makes—
But isn't that interpretation contrary to the language of ERISA?
I don't believe so, Your Honor, because the language of ERISA talks about the ability to have effective relief, and so the operative question isn't, can you do anything and everything under the sun in terms of monetary damages, equitable relief, and otherwise in order to pursue your claims, but rather, will this individual arbitration allow you to effectively vindicate the rights ERISA has provided to you? And I respectfully submit that the Supreme Court's decision in LaRue, which allowed for individualized proceedings in this type of ERISA regulated regulated plan means that individualized arbitrations are likewise consistent with ERISA. And if that's the case, if you can circumscribe arbitration or litigation to an individual claim in a defined
So
contribution.
is Larissa absolutely controlling here on all fours factually and the relief sought in the complaint by the plaintiff?
I think the allegations in LaRue were different, but I think the rationale of that case is controlling, particularly when the court considers it in light of the Viking River Cruises case, in which the litigant, the plaintiff in that case claimed, I'm not able to effectively vindicate the rights that the Private Attorneys General Act in California provides me because that act provides me the right to seek relief on behalf of other plaintiffs. That is the right to pursue other substantive claims that other plaintiffs would have. And because individualized arbitration in the Viking River Cruises case would have precluded that, the plaintiff in that case argued, he couldn't effectively vindicate his rights.
If the case were in federal district court, would the plaintiff in this case, be entitled to seek as an equitable remedy the removal of the fiduciary?
Yes, if the arbitration provision weren't.
Because ERISA statutorily authorizes it under Section 502, correct?
That is one of the portions of relief that ERISA authorizes participants and beneficiaries to seek.
And so why shouldn't we be bound by what Justice Scalia said in Italian colors? The effective vindication exception would certainly cover a provision in an arbitration agreement forbidding the assertion of certain statutory rights. One of those statutory rights, among others, would be the right to have the fiduciary removed.
That is one of the forms of relief available under ERISA, but I think the operative language that Justice Scalia authored in the Italian Colors case is in his description of the exception, which, by the way, the Supreme Court has never actually applied to invalidate an arbitration provision, in which he said, so long as the prospective litigant effectively may vindicate the statutory cause of action, then all of the goals of the statute are met. So the question is, in pursuing individual monetary relief, and if proving it in individual arbitration, getting all of the money and damages to which this plaintiff claims he's owed, is he effectively vindicating his ERISA rights? I think the answer to that question is yes, based on cases like McCutcheon, in which the Supreme Court said that it is protection of benefits that's at the heart of ERISA. So as long as you're allowing the plaintiff to protect his right to benefit.
So it's only money. If he gets his money back, his little tiny bit of money that's held up or caused to be reduced by whatever happened in this case, I won't describe it, that's enough, right? There's no opportunity for him to replace the fiduciary and say there was a breach of the fiduciary duty.
I would describe that as the effective vindication of this plaintiff's individual rights under ERISA. I would also note that it remains open to agencies like the Department of Labor to pursue other plan-wide or equitable remedies if it believes that such remedies are appropriate. But
You've just agreed that's an effective remedy. That's something that he should be able to pursue.
it is one of several remedies that the statute under ERISA allows him, but enforcing all of those remedies is not what effective vindication requires. Effective vindication, not perfect vindication, means can he do the core thing ERISA allows him to do, which in this case is pursuing the monetary damages to which he is entitled. Every other participant or beneficiary in the plan can, of course, seek their own monetary damages if they likewise believe they can prove they were harmed. And the Department of Labor, like the EEOC in the Gilmer case, remains available to pursue other equitable and plan-wide relief. The Supreme Court, I'm sorry, Judge Bacharach.
Is that because monetary remedies are more important than statutory remedies or than equitable remedies like removal of a fiduciary?
It is.
Why is it that your theory that it provides the core remedies authorized under ERISA because it allows monetary remedies but not these equitable remedies? Why is that? Is it because the monetary remedies are more important than the equitable remedies?
It's because pursuing those monetary remedies allows him to effectively vindicate his rights. I wouldn't describe it as a balance of importance. I'd describe it as evaluating whether the right as ERISA articulates it.
What if the arbitration agreement said you can only obtain equitable remedies and you can't obtain any monetary remedies? Would that agreement allow you to effectively pursue the statutory rights under ERISA?
Well, I certainly think that would be a difficult and perhaps different case than this one, because I think the statements in McCutcheon and others that describe the core of ERISA as protection of the benefit mean that it's that monetary remedy that is the core of what ERISA protects. So I think if you brought that litigation, you'd have to contend with that language in McCutcheon and other language like in Dudenhofer that talks about the importance of employee stock
Well,
ownership.
aren't you protecting the benefits if you get a fiduciary that's trustworthy? Isn't that a means of protecting the benefit?
I certainly don't contest that that is one of the remedies available in appropriate, as the statute describes it, in appropriate cases. So it's not an automatic remedy to which a plaintiff should be entitled, and it's certainly not one that would attach to every case. In fact, you could understand why it wouldn't attach in a case like LaRue, where there was an allegation that the $150,000 that particular plaintiff was due to him because of particular actions that harmed him alone. And so there wasn't a plan-wide remedy contemplated in that case, nor, I would add, would the other participants to that plan have wanted a plan-wide remedy. For all we know, they were perfectly happy with the way the fiduciaries in that case were
So are
operating.
you saying that the enforcement of the arbitration clause hinges on the pleading of the plaintiff? That is, if remedies are sought that are plan-wide, the arbitration provision is not enforceable?
No, I think the operative legal question is, can you enforce the FAA's commands to enforce arbitration provisions as written and still further the aims of other federal statutes when plaintiffs allege the two statutes conflict? Every time the Supreme Court has faced that question, it has found a way to reconcile the two statutes. And in fact, it's gone further than that to say that if a court is not going to reconcile the two statutes, the goals of the FAA, which mandate that courts enforce arbitration provisions as written, and the goals of other statutes here, ERISA and the protection of benefits to plan participants and fiduciaries, there has to be a clear statement in the statute indicating that the arbitration clause is subverted to the other federal statute. Here we have exactly the opposite. In ERISA, which was enacted after the Federal Arbitration Act was passed, 29 U.S.C. 1144 says nothing in this act should be seen to subvert or supersede any other federal statute. So ERISA contains a provision that says if there's a conflict, it's ERISA that gives, not the other federal statute. I respectfully think that that is the legal question the court has to grapple with. The court in Smith failed to do that. That was one of the legal errors that court committed. And failing to do so simply doesn't abide by the Supreme Court's precedent for how these types of cases are to be resolved.
Counsel, I was surprised. I thought you would have led with the Epic case.
I think Epic Systems is on point and controlling here. Likewise, I think Gilmer and CompuCredit are on point and controlling.
The arbitration clause in Epic provided the arbitrator could grant any relief that could be granted by a court, which is vastly different from what we have here, isn't it?
Well, the question the court faced in that case was whether a federal statute that contemplated a collective action scheme necessarily precluded arbitration, and the court said no. Likewise here, ERISA contemplates a collective action scheme, but that doesn't mean that...
But isn't that case clearly distinguishable because the arbitration clause is so different? That arbitration clause, as I indicated, provided that the arbitrator could grant any relief that could be granted by a court.
That is certainly a distinction, but the reason I think Epic Systems is important and relevant to this case is because there are three challenges the plaintiffs bring to the arbitration clause in this case. The first is that the arbitration clause has to fail because it doesn't allow for collective action. That is what directly contradicts the Supreme Court's holding in Epic Systems that said even if you have a federal statute that contemplates collective action there in the NLRA, in Gilmer, in the ADEA, in CompuCredit, in the Credit Repair Organization Act, even if you have a statute that contemplates collective action, you can still have individualized arbitration.
But the NLRA, as indicated in the opinion, Section 7 is really a collective bargaining provision, isn't it?
Well, it talks about collective bargaining. It also talks about
It talks about collective bargaining a lot, doesn't it?
And the right to pursue concerted action, which the plaintiffs in that case claimed entitled them to class-wide claims.
Isn't it further distinguishable that the claim that's made is not even an NLRA claim? It's a FLSA claim. Doesn't that clearly distinguish the case further?
It certainly means that the conflict alleged in that case arose from a different federal statute. That is a distinguishing factor, but I think the operative legal point is that when you have a federal statute that contemplates collective action, if you're going to find a conflict with the FAA, it has to be clear and it has to be obvious in the face of that second statute that the FAA is what gives. And here we have the opposite of that, as 1144 in ERISA makes clear. I'd add, I think the more recent Viking River Cruises case, as I suggested in my opening, is on point because it does address the question of substantive remedial relief. Can I bring substantive claims that I otherwise wouldn't be entitled to bring because this state statutory scheme there, the Private Attorneys General Act, allows me to do so, and that conflicts with individualized arbitration. There was an effective vindication argument made by the respondents on page 22 of their brief before the Supreme Court in that case, so there's no question that question was squarely before the court in Viking River Cruises, and it rejected that argument. Likewise, I think you have to reject that argument here. If I may, I'd like to reserve several minutes for...
Just a minute. The issue that the district court did not address, and that is whether or not the arbitration clause was effective because of notice. In the summary plan description, I note that it says that there's a statement of the participants' right to bring a civil action under 502 of ERISA following adverse benefit determination. It says that a second time in the claims procedure. And then later, it says, or you can do this administrative procedure, or you can file a suit in federal court. Doesn't that just kind of nail that issue?
No, because the operative legal document that controls arbitration or the ability to bring claims is the plan document itself. It's not the summary plan description.
Are you telling me if there's a misstatement in the summary plan, that that's just okay, you just overlook it?
I'm telling you, if there's a conflict between the summary plan description and the plan document, it's the terms of the plan document that control. That's the operative contract.
Why would a participant ask for the plan documents if it reads the representations in the summary plan description that they can file a suit in court?
Well, I suppose you could ask the plaintiff here who did exactly that, who requested a copy of the plan document, which plaintiff's counsel knew to be binding on the plaintiff, and then brought this lawsuit based on the terms of the plan document. That's a fundamental tenet of ERISA, is that the terms of the plan itself
Well, he was not
control.
obligated to participate in the ESOP, was he?
As ERISA defines it, once the plan is in place, continued
I
employment
understand,
is...
but as an individual, he was not required to use the ESOP for his retirement, right?
He could have resigned from the company.
You mean it's mandatory that you be in the ESOP if you're an employee?
Correct. There's no opt-in, there's no voluntary sign-up. Once the plan is in place, it binds participants and beneficiaries and fiduciaries alike. That is the core tenet of ERISA that the plan document controls. And frankly, I think that's a relatively uncontested proposition of ERISA. If the plan document didn't control here, there would be no claims to bring in federal court at all, because all of these claims turn on his alleged entitlement to benefits under the plan.
Uncle, I understand your point.
Thank you.
Thank you. I will go, even though you're out of time, I'm going to give you 1 minute for rebuttal.
I appreciate that. I'll talk fast.
We'll hear from the appellee.
Good morning, Your Honors. May it please the Court. John Stokes for the appellee, Robert Harrison. I'm splitting my time with Ms. Ballard from the Department of Labor. I'm going to stick to my 10 minutes to make sure she has plenty of time. This case is a textbook case of prospective waiver. If you're going to send a case to arbitration, the plaintiff must be able to pursue in arbitration all of the rights and remedies, the substantive rights and remedies that the plaintiff would be able to pursue in court. Here, there are multiple remedies that ERISA expressly authorizes that this court and others have approved in non-class ESOP cases brought under 1132A2, remedies that we seek in our complaint, but which are not available under the arbitration clause here, which is expressly non-severable. The clause is therefore invalid, and this case must proceed in court.
Well, can you control whether or not the arbitration clause is enforceable by the way you plead your case? If you throw in all of these means of relief, and does that get you past the provision?
Yes, if the statute allows us to pursue a certain type of relief, and we seek that relief in our complaint, the fundamental point of the prospective waiver doctrine is that relief must also be available to pursue in arbitration. That's exactly how it works. I suppose if there were a remedy we didn't seek, that couldn't be a basis for applying the prospective waiver doctrine. But if the statute allows us to pursue it, and we plead it in our complaint, and they write a non-severable arbitration clause that can't carve off that piece of it, then if we can't get it in arbitration, that is the paradigmatic circumstance where the effective vindication doctrine, the prospective waiver doctrine applies. And before I speak about any of the specific remedies, I want to address one very important point. There is no conflict here between ERISA and the FAA. The prospective waiver doctrine isn't some principle of ERISA that we're trying to import into the FAA context to avoid arbitration. We're not arguing that ERISA claims are non-arbitrable, or even that ERISA guarantees us a class action. That's not the point. The prospective waiver doctrine is a doctrine of the FAA. It comes from the Supreme Court's and this court's and other circuits' FAA case law, and it says it's a procedural safeguard for arbitration that says if you're going to have arbitration, you look at the statute that you're suing under to see if you can get all of the substantive rights and remedies. So I'd like to address the specific remedies and other substantive rights that we're talking about. And if you start, I think the easiest place is with fiduciary removal, which is just right there in the statute. It's in the words of Section 1109 as a remedy that is available for participants to pursue. And this court, in Eves v. Penn, it's a non-class ESOP case brought under 1132A2, approved of that remedy, of the fiduciary removal remedy. Now, Eves is a 1978 decision of this court. It's cited in our brief at pages 8 and 23 and 33. So we cited a bunch of times. But it's an older case, but it continues to be good law, and it's being cited at least in 2021 in this court's decision in Ramos as describing the appropriate scope of remedies under ERISA. So that's directly on point for our case as fiduciary removal being a remedy that's available to us. And as the Seventh Circuit recognized in Smith, it's a right that participants can pursue in court without a class, on a non-class basis, and it has to be available in arbitration. It's not, the clause is non-severable. That would be enough. Now, there are also other remedies, and I want to talk about the monetary piece of this because it's very important. There, too, the starting point is the statute, which speaks in mandatory and categorical terms. It says that in 1109, the breaching fiduciary shall restore any losses and disgorge any profits. There is no wiggle room there. And we've cited you to multiple decisions from this court and other courts, including Eves again, and the Brundle case, for example, from the Fourth Circuit, that have allowed individual plaintiffs in ESOP cases to pursue the entire loss on behalf of the plan. And I think the only thing that my friends on the other side have to say in response to that relies on a fundamental misreading of the Supreme Court's decision in LaRue. In LaRue, the only losses at issue in that case were losses associated with Mr. LaRue's individual account. And so people said, well, we have this language from Russell that talks about the entire plan. Your loss here isn't a loss to the entire plan. It's just a loss as to the plan assets that would be attributable to your account. And so you can't even sue under 1132A2. And the Supreme Court in LaRue said, no, that's not right. And the key quote in my eyes is at 256 of the decision in LaRue. And it says that both sides of the coin are incorporated in 1109. Whether the breach affects assets that are payable to all participants or only to participants tied to particular accounts, those are all plan losses that can be recovered under 1109 and 1132A2. So the court said that both things are part of what you can recover. The maximum case where you have a loss of the whole plan, and the case where the loss is just as to your individual account.
I have just a logistical question about the application of 1109. Now, in LaRue, obviously, it's understandable. It's one individual account, although the injury was to the plan. With regard to disgorgement of profits to the plan itself, Mr. Harrison wouldn't be able to get the remedy, whether it's in federal court or in arbitration, of all of the disgorgement of profits from the fiduciary, right? But the disgorgement would go to the plan.
The disgorgement of the profits would, as with the loss restorations, if there could be a distinction, all of it goes back into the plan. And that's a key point. A plaintiff under A2 suing in court cannot get like a check written to them. All of the money goes back into the plan and then, gets eventually distributed according to the terms of the plan. So if we, in Brundle, for example, the full, I think, was a $32 million loss that the plaintiff proved in that case. That loss gets put back into the plan as a whole. It doesn't go to the individual plaintiff. It goes into the plan. And
There is no individual claim under this ESOP?
No, there is no individual claim. And this, I think, is a fundamental point. And it goes to like the very nature of the claims here. So if you have a claim under, for example, the ADEA, like in Gilmer, the starting point is you can sue on your own behalf for injuries that you personally suffered. And the question in Gilmer is, can you waive the right to aggregate that individual claim with a bunch of other people's individual claim? Claims under A2 are fundamentally different. They can only, to your point, Judge Murphy, they can only ever be brought on behalf of the plan. There is no such thing as a non-representative claim under 1132A2. And the Supreme Court in Viking River drew a sharp and critical distinction between those two contexts. The aggregation class procedure context on the one hand, waivable, and the type of single agent, single principal, non-class representative claim that we're talking about here. That is part of substantive law. That is part of substantive law and is non-waivable. This is at 1922 of the Supreme Court's decision. And the examples that the court gave included like corporate derivative actions.
Well, let me ask you this.
Yeah.
If your client proceeded to arbitration on his, it would be the same relief. It would be plan-wide relief that the proportionate profit attributed to his account would just go back into the fund?
No, on multiple levels. So this is what I was getting at. The arbitration clause here says that you are not allowed to sue on a representative basis or a class or collective basis. So it says you can only sue in your individual capacity. It eliminates the right to sue in a representative capacity altogether.
I understand, but if he went ahead and arbitrated his individual claim, what happens to the money? Does it go to him directly?
Well, presumably that's how the arbitration clause is supposed to work. I think that by the terms of the arbitration clause, that is how it would work under the arbitration clause, which is inconsistent with how ERISA works. I believe that the defendants may have said in their brief, and I would note that that would still not be the full loss that we're allowed to pursue under 1109. So if the court has no further questions, we would just simply ask that you affirm. Thank you.
May it please the court, my name is Brendan Ballard and I represent the Secretary of Labor as amicus in support of plaintiff appellee. This case is reflective of a growing trend among employers seeking to avoid the full consequences of violating ERISA. By inserting into plan arbitration provisions waivers to plan-wide remedies.
Well, if everybody's doing it and it's bad, and you've seen that everybody's doing it and it's bad, then why doesn't the Department of Labor step up and take care of this?
In what way would you suggest that the
Bring
Department
an
of Labor
action in this case.
bring an action in this case? I mean, we're joining as amicus for the very reason that we want to let the court know that,
Bring your own lawsuit. That's what the defendants are saying. There is a remedy.
Oh, I see what you're
There is
saying.
a remedy here. The Department of Labor can come in full force and sue.
so what, in response to what defendant's argument, they're basically saying that the ability or the right to bring an action to remove a fiduciary, that they're conceding that that's inherently plan-wide relief that the arbitration provision precludes. But then they're saying that the participant's right can still be effectively vindicated because the Secretary of Labor can come in,
Right.
as you're referencing, and bring an action to remove the fiduciary. So I think that this is a red herring because the right belongs to the participant separately from the department. In appellant's interpretation, essentially you would have to alter the text of Section 502A2 by striking out a party that's entitled secretary and a participant. And you would also curtail the relief that Congress explicitly contemplated in Section 409A, which is to plan-wide relief. So, you know, maybe if the secretary, and the secretary has brought claims in many ESOP cases, but part of the reason that ERISA allows participants to bring these sorts of claims is because the Secretary of Labor does not have the resources to monitor every plan in the country at every juncture. So even if the court were to bring such an action here, or even if the secretary were to bring such an action here, it doesn't mean we would have the ability to do it in every single case. Therefore, that right would not be able to be effectively vindicated. But that's separate and apart from the key point, which is that this is a right that belongs to the participant separately from the secretary. And that's very clear from the text of ERISA.
What if the plaintiff were pro se, and there was this arbitration clause, and the pro se litigant seeks removal of the fiduciary? Would the courts still have to say, okay, well, arbitrator, you can adjudicate through arbitration the removal of the fiduciary?
So if there were no, yes, if.
It seems counterintuitive.
Well, in this case, keep in mind, there's the class action waiver and there's also this remedy limitation, correct? So if one part is invalid, all of it's invalid. But if we are talking about a provision that just has this remedy limitation that says that a participant may not bring a right on behalf of the plan for plan-wide relief, which is inherently removal of fiduciary, and we struck that down, yeah, the participant could bring that claim in arbitration. And that, you know, that would bind the plan, bind the fiduciary. And secondly, I just wanted to address quickly the other side's misinterpretation of Viking River. I think it should be really clear that we're talking about the effective vindication doctrine, which was explicitly reaffirmed there. The court in Viking River, it was in a footnote, but it said that the Federal Arbitration Act does not mandate enforcement of provisions that waive substantive rights. And that's what we're talking about here, not a procedural class action where individual claims are aggregated, but we're talking about a substantive single agent bringing in action on behalf of a single principal. And in Viking River, the court said that that was substantive, and that can't be waived. And it has nothing to do with the contrary congressional command doctrine. We're talking about here the effective vindication doctrine. And under the provision, this arbitration provision, the participant cannot effectively vindicate its substantive statutory right to bring an action on behalf of a plan for the plan-wide relief explicitly set forth in sections 502A2 and 409A.
And that was an ERISA case?
Which case?
The case that you mentioned that had.
Viking River was not an ERISA case.
Thank you.
Thanks.
Thank you, Your Honors. Judge Bacharach, I'd like to address your question about whether a pro rata share of profits are available in an individual arbitration. The answer to that is yes. It's found on page 119 of the appendix to this appeal that makes clear an individual in an individualized arbitration can receive their portion of the alleged harm and subsection 2, a pro rata portion of any profits allegedly made by the fiduciary through the alleged breach. So I think the answer to your question is yes, the pro rata share of profits are available. I'd like to also address the discussion of LaRue from my friend on the other side, which I think is just fighting the conclusion in LaRue itself. Justice Kavanaugh said you can bring an individual action pursuant to ERISA in LaRue. If you can bring an individual action, you can pursue an individual arbitration. And finally, to address the remedy question that DOL raised here, one, there's absolutely no reason this court should give deference to the Department of Labor in interpreting the statute. Epic Systems makes that clear. It's for this court to decide the legal question, not an agency. And if the court wanted to defer to the agency's expertise, I think it would have to consider whether to defer to the agency's expertise in this case or contrary positions that this agency has taken in other cases, including those pending in the Southern District of New York and the Second Circuit, that say an individual can pursue an individual claim in a way that doesn't eliminate the otherwise effectiveness of ERISA. Thank you.
Thank you. It was very well presented by both sides. This matter will be submitted. Thank you, counsel. Okay, the next case will be Landon versus Winston Hospitality, 22-1108, and we'll hear from the appellant whenever you're ready.
I told Appellant, the second cup of coffee may be a little much. Good morning.
Are you all ready over there?
Yes, Your Honor.
Okay, very good, sorry.
Good morning, David Lichtenstein appearing for the appellant Penny Landon. May it please the court. Pretext evidence can be used to raise an inference of discrimination for purposes of the prima facie case. That's a settled question, not just in this district under the Wells v. Department of Transportation case, but everywhere under the Reeves v. Sanderson plumbing case. The single most important fact in this case is one that bears not only on the pretext issue, but it's one that raises an inference of discrimination.
In both the two cases you've just cited, weren't those cases where the district court first concluded there was a prima facie case, and the case then proceeded to the usual three-part McDonnell-Douglas procedure, and that's why pretext evidence was admissible, because they were to that point in the case?
But both cases did observe that pretext evidence could be used to show the prima facie case.
Even though the prima facie case issue was already achieved?
Yeah,
Okay, just wanted to be clear.
sure. But the ultimate issue for purposes of the prima facie case is, do the facts raise an inference of discrimination? The single most important fact, I think, in this case is that Ms. Landon was terminated at a time when Delta 5 had a sales staff of 3 people, and the 2 men were retained. Delta 5 principally took the position that it terminated her because she was not making sales, and yet she had just made a sale that resulted in $20,000 in revenue to the company, and she had told the CEO, Mr. Winston, that she had made that sale. Meanwhile, no one else in the company for several months had made sales of more than $100.
Well, she hadn't made a sale because under the agreement, the sale is deemed completed when the product is shipped and it's been paid. And those two sales were never shipped, they were never paid, correct?
I don't believe that's true. They were shipped, and she was paid after she was terminated. She received commissions on those sales.
Well, that's sort of my point, is that it wasn't shipped and it wasn't paid until after January, until after she had been terminated, correct? Or am I mistaken on that?
No, that's correct, but this is a sign of performance. I mean, she has made these sales. No one else is making sales.
But I thought your point was, let's look at the facts at the time that she was terminated. And to Judge Bacharach's point, the facts at the time she was terminated, those sales had not been finalized, correct?
Well, that's correct, but she has certainly set the wheels in motion for those sales. I don't know if anyone else had done that. And she told Mr. Winston that she had just made those sales. And she was, of course, working on other matters. She was working diligently on bringing in a couple of major contracts with two large hotel chains. And that was part of her responsibilities under her offer letter. Meanwhile, part of the problem with everyone making sales was there wasn't sufficient product to fill orders. And she had even not been notified of a meeting in mid-December where this topic had been brought up. So, and she was also working on repairing the company's Salesforce system.
With regard to the shortage of product, as I understand it, Mr. LaBarbera says in his affidavit that once, when she first started, that there was a shortage, that there was an inability to ship product for one sale, and then there was another incident in December where there was one reference to the inadequate product to ship to one customer. But in your brief, you make it sound like, well, for the whole entire 5-month period, there was this, they never had any products for her to sell, and so it wasn't her inability to sell product, it was the shortage of product. I don't know that that's really fair inference if there's only 2 incidents of 2 isolated sales where they were not able to ship product. Am I mistaken about the record?
Yeah, I would correct Your Honor on that point. And one of the attachments to her declaration is an email which lists what happened at the December 14th meeting. And you can see from the notes, both the agenda for the meeting and the notes, that there are several properties where there's a problem with product.
But by then, there was August, September, October, November. Was there any evidence of an inability to ship product during those 4 months?
Well, I think that's what Mr. LaBarbera's affidavit is about.
I thought his affidavit was in the plaintiff's very first month. Are you sure that Mr. LaBarbera talks about that 4-month window? I may be wrong.
Well, yeah, I mean, he's with the company for approximately 3 months, and my recollection is that his declaration talks about it being a problem through the entire period. And certainly you can tell from the December memo that I just referred to that there was a problem all along.
When did he leave the company?
He left on December 3rd of 2018.
And he was there for 3 months?
Correct.
But he's fired because Winston's unhappy with LaBarbera's inadequate sales, right? According to Mr. Weehee.
I think it was general performance that Mr. Winston cited as the reason for terminating Mr. LaBarbera. But of course, this case is about Ms. Landon, not about Ms.
Well,
LaBarbera.
it is about Ms. Landon, except you're relying on Mr. LaBarbera for the prima facie case, at least in part.
Correct.
To say, well, before he was terminated, he said she was doing a dandy job. Well, it's just an odd situation with the decision maker, Winston, had fired the guy, LaBarbera, for inadequate sales, which is exactly, by the way, the reason that he says that he had fired Miss Landon. So it is a little bit of an interesting confluence.
Well, except that Ms. Landon is a salesperson, and she is similarly situated to the other two sales gentlemen. So Mr. Barbera has more of a management role, and I think that's what Mr. Winston was concerned about. And the favoritism that was given to the two salesmen is also a fact that is pretty important for showing the prima facie case.
How do you deal with, on page 282 of the appendix, where Mr. Winston says that Mr. Winston would have given Ms. Landon more time, except she was, shunning these repeated requests, I think from Mr. Heaton, or whatever his name is, for when he was trying to get the contact information for the fellow at Hilton, and he says, well, I would have given her more time, but she wasn't, sharing information. She was, she was being, she was being obstinate about that, and that's the reason that he didn't give her more time, even if she were otherwise similarly situated to Mr. Watts.
Well, and I would point out that the district court never reached that issue.
But we have to review it to know.
I understand, of course. But Mr. Winston admitted the primary reason that he terminated Ms. Landon was that she wasn't making sales. And, certainly the fact that if it's true, and we don't know because we don't have testimony or declarations from Mr. Heaton or the other gentleman who was sending her emails. We don't really know how critical an issue it was that Ms. Landon wasn't sharing that information.
But isn't it undisputed that they kept asking her for this specific information and she did not provide it?
That's correct, but we don't know the reason. We don't know if it's credible that it was truly urgent information. And
Why would that matter?
What? I'm sorry.
Well, I'm just asking, why would it matter if it was critical? Mr. Winston says, look, this is, Hilton's a big deal. I mean, you're the point person, this preferred status, for Hilton is a big deal, and you say, well, Ms. Landon was working on it. Well, Mr. Heaton is saying, yeah, you're out for 10 days. We want the information. So whether it's critical or not, why is it relevant for pretext, even if it wasn't important, even if Mr. Heaton was just wanting it to want it, why would it be relevant to Mr. Winston's pretext that he is crediting Mr. Heaton's repeated inability to get a phone number or an email address from Ms. Landon?
Well,
does that make sense?
I guess yes and no is my thinking on it. We don't know if it's critical. You have to wonder because there were other sources of other ways that Mr. Heaton and the company could get hold of these people.
Her private email? I thought the information was not stored where it was supposed to be. I thought she acknowledged that it was on her personal server.
Yes, but she never found out whether it was stored in Salesforce or not because she was terminated before she could find that out. So, it really isn't established that they truly weren't able to reach these people that they say was important to reach. So I don't know what else I can...
What evidence do we look at on the prima facie case for an inference of sex discrimination?
Well, again, of course, that she's let go and the other two gentlemen are...
Okay, that's number one. What's
okay.
number two?
The fact that Mr. LeBarbera told, or was told by Mr. Weehee at a time when Mr. Weehee was acting as his supervisor to put Watts Winston on a fast track. Watts Winston is scheduling sales calls and overseeing sales calls. They're sending him to the Virginia headquarters of Hilton at a time when Ms. Landon historically had been the one with the contacts at Hilton and had been working with the corporate people at Hilton. the company was sending both Watts Winston and Paul Mattabung on sales calls with Mr. LaBarbera and Ms. Winston, when historically they had never triple-staffed these sales calls. I find it really interesting the way the district court resolved this issue of whether the three people were truly similarly situated. I think there's a genuine issue of fact of whether their level of experience and whether the value of their experience was comparable to Ms. Landon's or not. And the court just resolves that by saying, well, it's just plain not comparable.
What does the record indicate as to when Ms. Landon came onto the radar of Mr. Winston for conduct that might justify termination?
Well, there are differing inferences that could be drawn.
Well, what is the evidence from which you draw an inference as to when she was on his radar?
Well, I think really at the time of her termination, I think that's the first time it becomes apparent that she's going to be terminated. In mid-December.
So that's long after Watts and the other fellow had been hired, correct?
Well, you could say it's long after. I mean, Mr. Mattabung was hired in late November. Watts Winston was hired.
Well, you're taking the position that Watts and this other fellow really were hired to replace her. Isn't that your essential claim?
I think that and just that they, when it came time to terminate someone, Ms. Landon was the one that's terminated and not replaced, by the way. But Mr. Winston had also told Ms. Landon in mid-December that she wasn't going to be terminated. And that's when she tells him, I've just secured these two sales.
Is there any evidence that Mr. Winston, who's the decision maker here, hired these two gentlemen in anticipation of firing your client?
Well, I think you have to look at all the circumstances, but I think the fact that almost immediately Watts Winston is again given these responsibilities that used to be Ms. Landon's, that he's suddenly again scheduling and overseeing sales calls, going to Hilton's corporate headquarters. These bespeak an intent on the part of the company. But again, when you go to the end where she's terminated, again, primarily because she's purportedly not making sales when in fact she has just, at least begun the process of making a sale through her own contacts.
Wouldn't that, in your answer to Judge Briscoe, wouldn't that preclude liability on your retaliation claim? After all, if Mr. Winston had hired Mr. Watts in November to replace Ms. Landon, your theory on retaliation is it wasn't until December in which Ms. Bell told Mr. Winston about Ms. Landon's complaint against Mr. Weehee. Well, if Mr. Winston had already concocted the plan to terminate her, well, he obviously didn't decide to terminate her in November based on stuff that he was going to learn a month later.
Yeah, I have to agree, but it's an alternative theory that if in fact he had not hired the other two to replace her, then that decision resulted from retaliation as a result of that meeting between Mr. Weehee and Mr. Winston in December. Well.
Thank you.
Thank you.
May it please the court. Good morning.
Good morning.
My name is Brett Wendt, and I'm here on behalf of the appellees in this matter. I want to jump right into a few things that this court has already identified and clarify some of the facts that are at issue in this case that haven't been wholly stated by my friends on the other side. The first of which is this notion that these two male individuals were hired to replace Ms. Landon, of which there's absolutely no evidence on the record of that. More importantly, Mr. Watts Winston was hired in November of 2018 to replace Ms. Ferlito, Ms. Landon's former boss, who quit in September of 2018, replacing her. Additionally, Mr. Matabang, the other male, replaced Ms. Pasquale, who quit in October of 2018. He started in December of 2018. These individuals weren't hired to replace Ms. Landon. They were simply hired to replace people that had quit.
But that's your theory of the evidence. I mean, isn't it, viewing the evidence in the light most favorable to the plaintiff, why isn't it a legitimate inference that, that these two individuals were hired in anticipation of Ms. Landon being terminated?
Because even taking the evidence in the light most favorable to the plaintiff, Your Honor, the simple fact that there were positions that were available due to no fault of Mr. Winston or the company itself that were replaced by men don't in and of itself derive an inference of discrimination sufficient to meet the element of the third element of the test. I would add that the argument that these gentlemen were treated somewhat differently or given different treatment is likewise misplaced. Again, they replaced individuals who had those roles and those responsibilities. It's also critical to note that Ms. Landon was a regional salesperson. She was housed here in Colorado. Mr. Batungang was hired to work on the West Coast, of which Ms. Landon said she thought it was a great business idea. Mr. Watts Winston was working on the East Coast, which is one of the reasons he went to Hilton, which is based in Virginia. And in spite of the fact that Ms. Landon claimed she had all these contacts, she was being misfavorably treated, and that she was being shut out, why does that explain why she hadn't had a sale since August 7, 2018, if she really had all these contacts and was making headway? The reality is that she hadn't made a sale in 5 months prior to her termination. Along those lines, as this, I think Judge Briscoe or Judge Bacharach properly asked, was there any other reason why she was terminated? Well, yes, there was. Not only was she not performing the essential function of her job for almost half the time she was employed, yet drawing a six-figure salary, but as you point out, in December of 2018, merely a month before she was terminated, it was discovered when she was out that she was not inputting her contacts in Salesforce, which was a requirement of the company so that everybody could share information and not lose sales that were being generated. To make matters worse, once that was discovered and she was asked or directed to provide that contact information, she refused. These reasons, in and of itself, do not create an inference of discrimination based on her termination that occurred on January 16, 2018.
For a prima facie case, why isn't it, again, viewing the evidence favorably to the plaintiff, enough to find an inference that she was terminated, based on gender, that Mr. La Barbera, within 6 weeks of her termination, had said that she was doing well. The plaintiff has evidence through Ms. Landon that Mr. Winston had told her roughly at the time that Mr. Barbera is terminated in December, that she is not going to be terminated. She tells him that she has been able to land 2 sales, albeit it hadn't been consummated yet. There are these 2 individuals that, at least in Mr. Watt's case, had been there 3 months without a single sale. And it is a minimal burden for a prima facie case. Why isn't all of that sufficient to lead a reasonable fact finder to find satisfaction of a prima facie case?
I think there's 2 reasons, Judge Bacharach. The first of which is assuming for a minute and dismissing for purposes of this response the admissibility of Mr. La Barbera's affidavit. I would suggest 2 things. One, Mr. La Barbera only worked at the company for less than 3 months and had very limited experience or exposure with Ms. Landon. Additionally, as you point out, Mr. Watts Winston had only worked there a totality of 3 months when Ms. Landon was fired, and Mr. Batung had only worked there about 6 weeks. Ms. Landon had had a year to prove herself. These gentlemen, who are the alleged comparators, which is a different discussion, had just begun. And most critically, Your Honor, is it in the time that they overlapped, meaning the 5 months from August 7 till January 16, and the 3 months that Mr. Watts Winston worked there, and the 6 weeks that Mr. Batung worked there, none of them made any sales. Nobody was selling. And as I mentioned to you a moment ago, which was, again, ignored by the other side, when Mr. Winston had this meeting in December and talked to Ms. Landon about her performance and that he wasn't intending to fire her, This was before she went out on sick leave, and she was insubordinate and was not following company protocols and not helping the business grow and sustain. That there's no evidence to suggest that these other two gentlemen that the other side wants to compare engaged in any of this behavior. The reality is that none of the three of them were making sales. And to answer your question about the prima facie case, as Judge Briscoe led off with at the outset of comments by the other side, the cases cited did get to the issue of pretext, but there are two other cases that I think are more instructive, Your Honor. As a matter of fact, this court in Abramson v. Multi-Community Diversified Services affirmed summary judgment in favor of defendant, where the district court found the plaintiff failed to establish his prima facie case of discrimination, affirming without reference to defendant's proffered reasons for their terminations, meaning they never got to pretext. This court affirmed that ruling. With respect to Ms. Landon's other claim of retaliation,
I know we can't unwind this, but my, wouldn't this case have been simpler if the court would have said, okay, since the burden to establish prima facie case is so minimal, we'll just give you that. And you've spoken, and even opposing counsel has spoken, about activities by the plaintiff, which arguably would be pretty good reasons to fire her. So then you're in the world of pretext. And that's really the difficulty in our trying to pull this apart right now, is that it's presented as a case of prima facie, but we keep talking about pretext.
it is a blurred line, Your Honor, and if I may address this in two parts. The first of which, just to finish my thought on the question you asked earlier, and that is, goes hand in hand with the second claim that Ms. Landon brought, and that's for retaliation. This court affirmed the district court's grant of summary judgment at the prima facie stage of a retaliation claim, holding that the plaintiff failed to provide any evidence demonstrating a causal connection between her termination and the protected activity, thereby failing to establish a prima facie retaliation under Title VII.
And that case that you...
Lowe v. Angelo's Italian Foods. Next, moving to the more substantive question you asked about how this case could have been more simply resolved had the district court just jumped straight to pretext.
It's a pointless question, but
Well, maybe
it does
not.
strike me as pretty obvious here.
Well, this is, you're reviewing this de novo, and I guess assuming arguendo that this court were to find the plaintiff did meet her prima facie burden of proof, you should nonetheless affirm the district court's ruling of summary judgment in favor of defendants, and here's why. Assuming again arguendo the plaintiff would have made her prima facie showing, the burden, as you know, would have shifted to defendants to articulate a legitimate, non-discriminatory reason for Delta 5's decision to terminate her. Delta 5 terminated Ms. Landon because the last 5 months of her employment, she hadn't made a single sale. She wasn't doing her job. As I mentioned a minute ago, it was also discovered she was violating company policy and was insubordinate when asked to rectify that situation.
Let me interrupt you.
Yes, Judge Murphy.
On your road down to pretext, and go back to prima facie case. And the issue, and the only issue, as I understand it, was whether her position did not remain open. That's the only issue on the prima facie case, right?
I don't know that that's the only issue. I think the first issue is whether there was even an inference of discrimination. If we get past that, then we can talk about whether or not that position stayed open.
Prima facie case. She's a member of a protected class, right?
Yes, sir.
The district court said she was qualified for the position, at least go to the jury. She was discharged. That only leaves one last thing, and that is whether her position did not remain open. Isn't that the way we should look at the prima facie case?
It's the way we look at the prima facie case, but the element that's being missed there is that there needs to be an inference of discrimination before we look at that element. And in this case, the position was open for a period of time,
Well, okay.
but without, yes, Your Honor.
Okay. Let me talk about whether her position remained open. There was a person that was hired in May, correct?
In April or May, yes, Your Honor.
Yeah, and did she fill that position?
Partially. This individual did not have the same role or responsibility as Ms. Landon did and was not located in Colorado, but this person did support the company in a sales role.
Well, does that mean that her position did not remain open then? It was filled in May?
Ms. Landon's position did not remain open. As a matter of fact, no positions remained open, but Ms. Landon's position did not remain open, no. It was not replaced by somebody in her situation.
Okay.
If I may finish with Judge Briscoe's question about pretext, if, as you know, Delta articulated legitimate non-discriminatory reasons, then the ball would bounce back to Mr. Landon to show that Delta 5's proffered reasons were inconsistent, implausible, incoherent, or contradictory, and that they were unworthy of belief. If the district court were to reach this element, the result would have nonetheless been the same. In reaching that conclusion, it would have eliminated, as you mentioned, Judge Briscoe, a lot of the back and forth that we've discussed today and some of the elements of the prima facie case that are perhaps.
But if we affirm for an alternative reason, don't we have to look at whether or not the parties have had an opportunity to address the question and also the district court?
The question was actually addressed and briefed in both parties' briefings, Your Honor, and that is at.
So those points are satisfied. This is not something we're just pulling off the shelf.
No, Your Honor, those elements have been satisfied.
Good.
And it is supported by the record at appellate brief pages 21 and 22. And
Of your answer brief.
Yes, Your Honor. And it was also addressed in the underlying pleadings.
When you say your pleadings, in your motion for summary judgment?
Yes, Your Honor. And if you were to apply this standard, Judge Briscoe, I believe the court would find, as it did in Johnson v. Weld County, as you started this, and affirm on other grounds in favor of defendants, which is what we're asking you to do today.
So that's what you're doing. You're saying affirm for an alternative reason?
I'm suggesting based on
Affirm
the,
any way we possibly can.
I'm suggesting that based on the evidence that was admissible and in the record, this case should be decided as the district court did based on failure to establish a prima facie case. However, assuming that is not the court's inclination, it would nonetheless find the same conclusion as it did in Wells in applying pretext. So if there's nothing further, I'll finish. Thank you both. Thank you all for your time.
All right, thank you very much. Nikki, I think the appellant's unfortunately out of time. Is that correct? All right. Thank you very much, counsel. This matter was submitted. And then we'll move on. You okay? Okay.
Good.
We'll go into Cleveland versus Auto Owners, 22-1109.
Could someone close the back door, please?
May I begin? Good morning, and may it please the court. My name is Bastian Kane. I'm appearing today on behalf of the plaintiff appellant, Susan Cleveland. Good morning, counsel, my colleagues, on behalf of auto owners. I want to start this way. This was a case that was removed to federal court. It's under diversity jurisdiction. Under the Erie Doctrine, absolutely, Colorado substantive law applies. Under Colorado substantive law, in order for an insurer to vitiate, in order for coverage under an insurance policy to be vitiated, two things have to happen. Number one, there has to be a failure to perform. And number two, an insurance company must establish that the failure to perform, in this particular case, the non-cooperation, was material and substantial. And not only that, but that they were materially and substantially disadvantaged. And what does that mean? That means that they were prevented from being able to investigate the case or defend the claim. Now, I'm scratching my head as to why we're here today. The auto owners filed this motion for summary judgment 2 months before discovery cutoff, 3 months before the dispositive motion deadline.
I didn't hear the last part. Say that again.
Auto owners filed its motion for summary judgment 2 months before the end of discovery cutoff, 3 months before the dispositive motion deadline originally. No 30B6 deposition had been done. Expert disclosures hadn't been exchanged. No rebuttal expert disclosures had been exchanged. No depositions of experts had been done. None of those things. So, what did Cleveland do? Cleveland, following the guidance of the U.S. Supreme Court in Celotex versus Catred, filed a Rule 56D motion. Because the summary judgment motion was premature, Cleveland filed a motion for an extension of time to do additional discovery. That's exactly what the Supreme Court says you do when there's a premature motion for summary judgment. That's what Cleveland did. And filed it well within the time limit. It wasn't late, nothing like that. So, 9 months and 18 days passed. And what happened in that 9 months and 18 days?
The 30B6 deposition had been taken.
I'm sorry?
I'm sorry, I know it was a rhetorical question, but I'm trying to answer your question. In one of the answers, the 30B6 deposition had been completed. And after all, in your 56D motion, the only ground that had been asserted was the 30B6 deposition had been completed, and there was additional time to do that. And then there may be additional discovery that emanates out of that 30B6 deposition. So that 9-month period had allowed the 30B6 deposition to be completed and presumably any follow-up discovery that had emanated out of answers to the 30B6 deposition. So why isn't that exactly what happened in Alpine Bank? That 9 month, that the allowance of the ability to supplement the Rule 56 response, you didn't do that. And so why wasn't it within the discretion of the district court to say that I'm going to deny the motion to stay under 56D, just like Alpine Bank?
Well, I'll be honest with you. I don't know the facts of Alpine Bank, but I will say this, is your characterization of what happened here is not what happened here. And let's start with the Rule 56D motion. Rule 56D motion, and you'll find it in Volume 3 of the appendix, I believe at page 71, 72, that right around there. What you're going to find is that Mr. Bolich, on behalf of Ms. Cleveland, asked for additional time to do the 30B6 deposition and also to do additional discovery emanating out of the 30B6, and specifically said in the request for relief, 20 days past discovery cutoff. That's exactly the relief that was requested. The district court made an error.
We all know that. But
Okay.
my question is, when you ask for, whatever you ask for is whatever you ask for, but I don't know that makes a hill of beans difference. The motion for a stay you're asking for relief that was totally disconnected to the grounds for the stay. The grounds for the stay was just what you said. The 30B6 deposition hadn't been taken, there was additional time for that, and there was a need for additional discovery that would have grown out of the 30B6 deposition. Now, in your prayer, you did say we wanted to have 20 days until after the discovery cutoff date, but if you were the district judge and you read that request, what would you say? Well, wouldn't you say, well, they asked for 20 days after the discovery cutoff date had been completed, But why? They don't need anything other than the 30B6 deposition and the discovery that grows out of the 30B6 deposition. Wouldn't you say that if you were the district judge?
I would not, Your Honor.
Okay.
Here's why. Is during that time period, the parties were actively litigating and actively engaging in discovery. And there were delays. There was a previous delay based on the 30B6 and fighting over the topics, okay? Then after that, there was extensions of deadlines for the expert disclosures and those sorts of things. And I want to make this important point. There were 5 times in this case where the parties filed unopposed motions, both Cleveland and auto owners filed unopposed motions to extend these deadlines, right? Those all got filed with the district court. And if you look at the record here, the district court was a participant in all of those and referred them out to Magistrate Judge Newrider. So the district court knew that the parties were actively continuing to engage in the very discovery that was mentioned or that was contemplated by the Rule 56D motion. So I hate to use the word disingenuous, but it's disingenuous. I believe it was disingenuous for the court to say, well, you only asked for completion of the 30B6 deposition. That was clearly a clear error of fact, by the way, which demonstrates an abuse of discretion in ruling on in her denying of in the district court's denial of the Rule 56D motion. That was a clear error of fact. And I think we just did a pretty nice job demonstrating that in the briefs, and I'm not going to belabor that here. But it was a clear error of fact. But turning back to the other, it was also an error of law. The other reason the district court gave was it said, look, the plaintiff doesn't need any discovery to demonstrate its performance element. Well, okay.
That's actually factually true, isn't it?
Well, here's the thing about that, Your Honor, is, I scratched my head a little bit when this case came to me because, I read the motion for summary judgment, and I said to myself, what on earth is going on here? Auto owners specifically admitted in their statement of undisputed facts that Ms. Cleveland performed.
We read that argument, but my question, and maybe I asked it poorly, but when you said that the judge got it wrong, that the plaintiff knows what she did and what she didn't do, I'll just ask, that is factually correct, isn't it? Now, you have a separate argument that the defendant admitted that she satisfied that she provided everything that she needed to do and that there was an admission from the defendant. But it was factually true that she knew exactly what she had done and not done. That's all the judge said, right?
Well, I think if you're going to read it that narrowly.
I thought that's what you had said. I'm not reading it narrowly or broadly. I thought I was paraphrasing you.
Well,
what did the judge say? Tell me what the judge said and what is factually inaccurate about the book.
Well, the bottom line here is that the performance element in and of itself doesn't get auto owners anywhere. Under Colorado law, it's clear that for them to initiate coverage, they have to establish they've been materially and substantially disadvantaged. Now, if you look at the motion for summary judgment itself, okay, there's about 2 pages on performance, right? And then auto owner spends the rest of their time talking about non-cooperation and the second half of the analysis, right? So for the district court to say, well, plaintiff didn't need anything else with respect to the performance element. Let's think that through for a moment logically. Now, assume that Ms. Cleveland had responded to the motion for summary judgment by saying just that. We didn't respond, right? Basically what the district court said, if you followed it through, right? Well, then there would be an entire rest of the motion that the plaintiff would not have been able to respond to. You know why? Because how and in the manner in which auto owners claim to be materially and substantially disadvantaged in their investigation, that was within the control of auto owners, not Cleveland. Cleveland can't reasonably know that. And when you look at the material in the record, and I believe we did a good job of putting all this in the brief as well, the district court ignored the fact, number one, that I already said, that auto owners itself admitted that Cleveland performed. All this motion really is auto owners doesn't like how Cleveland performed, but that doesn't.
They had just acknowledged that she had responded to one of the 17 letters. Am I wrong about that?
Maybe, Your Honor. I mean, that's going pretty back deep in my memory. But
And so if it insured over a period of 1 year and 9 months responds to one out of 17 requests that never provides a medical release, that in itself, as a matter of law, is an admission that she cooperated?
well, let me back up. That's not the only thing they admitted. They also admitted that they received medical records, right? And
Just a few, not everything they asked for.
oh, well, right, but under Colorado law, that's irrelevant. I mean, it's irrelevant that they don't get everything they want. All these cases that involve non-cooperation, they're founded on the premise that an insured doesn't do every little thing that an insurance company asks it to do. And that's really what goes on here. The insurance company, they just send out form letters every month. It doesn't matter if you send them a pile of records 3 days before. It doesn't matter if you got them on the telephone. It doesn't matter. They just send out letters. That's what they do. They also,
Well, I think certainly in this case, it came to matter, didn't it?
I don't believe it did, Your Honor.
Well, the court ruled against you.
Well, the court,
For lack of cooperation.
Right, but the court ruled against us, like she erred, the district court judge erred as both a matter of law and a matter of fact in denying our Rule 56D motion, right? Because we have a defense. Ms. Cleveland has a defense to this.
And the error there is that you asked for time and you were not given full time? Is this the 20 days add-on that you had in your prayer? Is that what we're looking at here?
Well, there's that, and then also we weren't done doing discovery. We weren't done. I mean, there was expert reports, but there were still depositions set to be completed.
Right.
I mean,
But you hadn't in this interim responded to the motion for summary judgment, is that right?
I'm sorry, Your Honor?
You had not in this interim responded to the motion for summary judgment?
Well, no, we hadn't, and to be perfectly honest, Your Honor.
That's pretty risky business, isn't it?
What's that?
That's pretty risky business, isn't it?
Well, I think you have to think back to the time period we were in. I mean, we were firmly in the grips of the COVID pandemic, and the vaccine had just been rolled out, and they were doing it in stages at that time. It absolutely, especially considering the fact that the district court itself was a participant in all these motions to extend the deadlines. And by the way, both the magistrate judge and the district court judge, in overriding auto owner's objection to the 30B6 deposition notice, everyone was on the same page that the non-cooperation piece mattered. And so for the district court to all of a sudden say, well, nobody ever objected to this all along the way. And then 9 months and 18 days later, we get a ruling denying the 56D motion. Denying the 56D motion and granting the summary judgment motion. Now I'll say, this court has said before, the better practice and what should happen is that a district court judge should rule on a 56D motion before it rules on summary judgment. And to the extent that the district court didn't do that here, we argue that's an abuse of discretion. Well,
had all discovery, all the extensions that you'd asked for discovery, had they expired by the time the district court ruled on the motion for summary judgment?
Absolutely not, Judge.
Absolutely not. Okay, that's the 20 days.
The discovery cutoff had been, I'm sorry.
Is it the 20 days that we're talking about?
The discovery cutoff had been moved to October 31st. And the district court judge entered its motion denying the 56D motion and granting summary judgment on September 23rd. And it specifically said in there that all the discovery requested in the motion had been completed 4 or 5 months earlier.
Thank you.
Thank you.
Thank you.
May it please the court, John Marinas for Appellee Auto Owners Insurance Company. The judge said the relevant discovery was completed. The only relevant discovery specified in the 56D affidavit to support their motion to stay was to request a 30B6 deposition of auto owners in order to explore the prejudice issue. They also said in that 56D motion that they also needed some other baseline discovery as well. And under the ruling in Wilson, which is cited in the papers, a 56D affidavit and motion have to be robust. They have to be specific. You can't just say, I need baseline discovery in order to respond to a pending motion for summary judgment. The judge was very clear that she said the relevant discovery that you wanted was completed, and that was the 30B6 deposition of auto owners. And I'd really disagree with the context that was painted here. Expert disclosures had been completed according to the court's record. When you look at what was in front of Judge Arguello at the time she entered the summary judgment order, the only remaining extension was to do a rebuttal expert, and then the last one made was to take depositions of two of auto owners' experts. One was a medical doctor and one's an accident reconstructionist. You don't need a deposition of an accident reconstructionist and a medical doctor in order to respond to an issue of prejudice. That extension for those two depositions only was the only basis for extending the discovery cutoff to October, and it was October 30th was the extended cutoff date. So discovery was extended to October 30th. It was only to take two expert depositions that have nothing to do with being able to respond to a summary judgment on the prejudice issue. And the Rule 56D motion did not specify that they needed to take these two expert depositions in order to respond. They only said, we need the 30B6. They got the 30B6. They sat on it for 3 months, and the judge ended up ruling. And I think there's a case out of the Fifth Circuit of Beatty. It's a 2001 case, but Fifth Circuit said, if you're gonna ask to suspend discovery, you're gonna do it at your own risk. And that's something that's repeated on these 56D motions. You have options when a summary judgment is filed. You can challenge the summary judgment head on and say, I, Miss Cleveland, performed, and there is therefore a genuine fact issue here. They could have alternatively argued, auto owners didn't meet their burden of proof under the summary judgment standards to be entitled to summary judgment. Kind of a third option that they're allowed to is say, time out, I need more time to do discovery. But under Rule 56D in the case law, especially the Wilson case, says if you're gonna do that, you gotta be specific, you gotta be robust. And the specific discovery that was requested in the 56D motion and the affidavit to support same was the 30B6 deposition of auto owners. They took it in May. And what was in front of Judge Arguello when she's looking at that, she sees a status report seeing the 30B6 deposition is scheduled for May. She waits until the end of September to make her ruling on both the 56D motion for stay as well as the 56D motion for summary judgment. The plaintiff did not file something after the 30B6 motion saying, hey, Judge, here's a status report. The 30B6 opened a lot of bunny trails that I need to explore with more discovery to look into prejudice. They didn't do that. They could have done that. They didn't do that. They stuck to their guns of saying, I need a 30B6 deposition. That was their chosen strategy. And the problem is they just didn't take it all the way through. That was a chosen strategy.
One thing that the judge did say, I think, is that the parties had stipulated that the discovery would be completed, I think, by September. Is that right?
At one point, yes, Your Honor.
And she says that. And the ruling on 56D is a matter of discretion. And so if a court does, and that was factually inaccurate, if a district judge in exercising her discretion relies on a factually incorrect statement, can we really be assured that the district judge would have reached the same decision, would have exercised her discretion in the same way that she did in the absence of that factually inaccurate statement about the timing in which the discovery would be completed?
Her assumption when she issued her order on summary judgment is that discovery had been completed earlier in September. She issues her order on September 23rd of 2021. It goes back, and my response would be this, is that the only thing, if that was clear error, the clear error was that the discovery was kicked to October 30th for the purpose to take these two depositions of a medical doctor and an accident reconstructionist that have no bearing whatsoever on how to be able to respond to a summary judgment about your lack of cooperation and the prejudice that owners had suffered as a result of it. Owners, prior to them filing lawsuit, owner had given 3 coverage position letters to Ms. Cleveland saying, you did not respond to a ton of our letters. You did not notify us of a lawsuit you filed in the against the underlying at-fault parties, and you didn't tell us for 480 days. And by the time you told us about the existence of that lawsuit, auto owners tried to jump in and intervene in that lawsuit to protect its rights. And that trial court said, no, we're too close to trial. You can't do it. The discovery's cut off. You can't intervene. And then that underlying trial got a mistrial. And then auto owners even filed a motion to reconsider to try and jump in to intervene in the lawsuit to protect its interests. And the court said,
Assuming what you say is correct, and that is these depositions after the 30B6 were really irrelevant to performance, couldn't the plaintiff be thinking that even though there's a pending summary judgment motion after the 30B6, is that the discovery cutoff is still not till September? So there's no emergency here to get the response to the motion for summary judgment.
I guess my response to that is the case law that says, if your decision, your strategy is to file a 56D, you're rolling the dice of whether or not you're going to be granted that 56D motion.
I'm talking about the discovery cutoff, which the court order is not until September. So if I wait from May until September, thinking the discovery, you file the response to summary judgment after discovery is cut off.
That's assuming you know what the trial judge is going to do, and as an advocate, you do that at your own risk. You have a floating summary judgment, you have a case-killing motion pending against you, and you're hoping and assuming that the judge is going to rule the way you want to or interpret her orders the way you think that should be interpreted. That's at risk, and that's, again, why these cases say if you're...
Normally, in a pretrial order, you have dates set for deadlines for filing summary judgment and deadlines for responding. That didn't happen here.
Well, the pretrial conference got vacated in this case because of the length of time that the 30B6 dispute was going on and the September 20th, 2020 ruling occurred. But yes, there was a scheduling order with original deadlines of what the discovery cutoff would be. And I agree that the parties can't abide by that. My
Okay, but the initial discovery cutoff was changed, altered.
Yes, Your Honor.
And was it done by a court order?
Yes, Your Honor.
Okay. And that court order put it to September 23.
It put it to, I think it was a September 5th or something like that was.
Okay, early September.
Sure. And then there was a motion filed saying we need more time to take these 2 depositions. The basis for requesting the discovery cutoff to get extended was those 2 particular depositions, but the way the order came out is said the discovery cutoff.
Everything got upset here in the scheduling. Was there a subsequent order as to responding to the summary judgment motion? Or was there any subsequent order that did scheduling for summary judgment?
Not on the dispositive motion deadline. All of the moving parts, so to speak, in the scheduling order all dealt with discovery or moving experts or that type of thing.
The scheduling for dispositive motions was, that deadline expired long before the discovery cutoff.
I guess technically speaking, if you want to look at it that way, that statement could be made, but that is not an argument. That is not an argument that's ever been made by plaintiff in any of their filings.
But once you've reached this cutoff that we're saying is September 5 roughly, and you said there was another motion filed by the plaintiff?
It was actually an unopposed motion for them to take auto owner's expert, those 2 depositions.
So that's when the district court, I guess, thought, you don't need this for the issues at hand. I mean, that's your argument today.
Correct, Your Honor. and if that's the specific discovery they needed in order to respond to the summary judgment, that has to be specified in your 56D motion, or at least file an amended 56D motion or a supplemental 56D motion to
So
say,
isn't that what they were doing when they filed this subsequent motion? This motion that was filed by the plaintiff after the September 5 cutoff? Aren't they saying, hey, we still need more discovery?
in order to take 2 depositions of 2
Correct.
experts.
Yes.
That's what they were requesting, Your Honor.
Okay, that was in the motion. Did the order granting the motion limit it to those 2 depositions?
No, the order was more general. It said discovery cutoff is extended
It's the
to
order
October
that
30th.
The magistrate judge entered.
Correct, Judge Newrider, magistrate. And I guess I'd like to back up now of what is cooperation in Colorado, and it's been described in a few cases, and I want to make sure that the court has a good understanding of this, is that in Hansen v. Barmore, the court said, these are Colorado substantive state law cases, cooperation requires joint operation and common labor. Joint operation or common labor, that is what cooperation is. So when Auto Owners is sending out 17 letters asking for medical records, is she still treating? If she is, please provide those records. For, over a year and a half and asking for that information, cooperation requires joint operation or common labor. Another case, the Brecky case, 105 P. 3rd, 177, jump page 189, talks about the insured's duties of cooperation and reporting to the insurer. And finally, the Fisher versus State Farm case, the Court of Appeals case, not the Supreme Court case, 419, jump page 993, it approved the jury instruction to say that the duty of cooperation also exists and for the policyholder to assist with the claim. Now, there's this idea, I think, in their mind that insurance companies, there's a secret database where they can get everyone's medical records, or they can just call a doctor and say, hey, violate HIPAA and talk to me about this. I'm a stranger, you don't really know me, but talk to me about your patient, the treatment, and the injury. There's no secret place to get that stuff. In the claim process, you have a give and take, and you need this information from the policyholder to say, what is your claim? What are your damages? Are you impaired? We haven't seen a medical record saying you're impaired. Impairment damages can be a huge significant amount. Never got any information about that. In October 2017, when Ms. Cleveland's attorneys did respond to one of the requests for auto owners, that October 2017, that's what they're saying, auto owners in its motion for summary judgment, that's an admission that she performed because she submitted this email in October of 2017. Please read that October 2017 email. It is located in volume 7, the sealed volume on page 11. That email from the lawyer's office says, we do not know for certain if there will be UIM exposure. It further says, attached are medical bills and records to be paid from her med pay coverage. And this is significant. These are sophisticated lawyers talking about what they're seeking and what they're wanting from the insurance company. And here they're not even saying pay these under UIM coverage, they're saying pay it under med pay coverage. And this is important because in Calderon, you cannot set off your UIM limits through a med pay payment. So, for example, under med pay coverage, it's usually around $5,000 or $10,000. Let's say you have $25,000 UIM policy. If an insurance company pays $5,000 on the med pay, the UIM doesn't come down from 25 down to 20. So the insurance can't say, hey, we paid $5,000 in med pay over here, therefore your UIM limits shrink. That doesn't happen. Calderon said you can't do a set off. So they can make a claim for entitlement to UIM benefits. And here, their October 10th, 2017 email saying, we don't know for certain if we have UIM exposure to provide here, but please pay these medical bills under med pay.
You need to wrap up.
And that's a huge admission. We just asked for the court to affirm the rulings of Judge Arguello in the trial court.
Mr. Marinus?
Yes, sir.
I'm reticent to do this, ask a completely irrelevant question, but my curiosity has gotten the best of me. Why did you need an accident reconstruction expert if you've already had prime window and Mr. Abbey prevail on the negligence issue.
Because we weren't bound by the findings of the trial court because we were prejudiced and couldn't intervene. And under Briggs and Brecky, the UIM carrier is not bound by those findings. So in their UIM claim, in this claim, we would have had a trial on what were liability and damages that they suffered and did it exceed enough to force UIM benefits to be owed. That answers your question.
That's why my curiosity should have been suffocated.
That's all right, Your Honor. Thank you.
Thank you. Nikki, is the appellant out of time? All right, thank you. It's very well presented by both sides. This matter is submitted. Okay, our last case of the day is, well, I don't know how to say it. Giertz, did I butcher it?
Giertz.
Giertz, okay, versus State Farm, 22-11-14.
Good morning, may it please the court. My name is Sean Connolly, and I represent the plaintiff appellant, Amy Giertz, who is present here in court. Ms. Giertz was seriously injured in 2016 when a car invaded her bicycle's right-of-way, knocking her to the ground and into a hospital. She sued her own insurer, State Farm, for bad faith denial of benefits under her own policy. The trial court allowed State Farm to avoid trial on its bad faith and instead dismissed those claims with prejudice on a ground contrary to Colorado substantive law.
And when that dismissal occurred, did you object?
No, Your Honor. Well, we objected beforehand, but what happened is the jury returned a verdict on a very truncated claim on day one, and the very next day, the court entered judgment.
And then post-trial, post-judgment, was any motion filed?
There were
to
no
say,
59 motions.
Hey, wait a minute, we've still got bad faith hanging out there.
No, that was actually done ahead of time in multiple occasions, saying you can't do what you're doing that led to that judgment. And so our appeal today challenges the bifurcation orders, 2 of them, and then the evidentiary rulings that led to this effect. So beforehand, everybody knew at the time of trial what the judge was going to do, and that's why he did it within a day. It was a perfunctory thing. The jury verdict came back on a really a car versus bicycle or bicycle versus car negligence action. But before that, the trial counsel had very strenuously objected in 3 different times to saying you can't do this. You cannot rewrite substantive law of Colorado. And you
But
can't.
I thought we had subsequent agreement by counsel for plaintiff here to the bifurcation. Twice.
I don't
mean,
believe so.
We have 2 different orders. First we bifurcate it, then we bifurcate it yet even again.
Yep.
And it seemed, in my reading of the record, that there was no objection to that. In fact, the counsel said, hey, good idea, looks good.
Let me go through the procedural context if I can. And Your Honor, and it's really the 3 orders that are challenged are addendums 1, 2, and 3 in our opening brief. So first of all, there's a motion for bifurcation. Addendum 1 is the order granting bifurcation. On appendix page 130, I think it's page 3 of that order, the judge says plaintiff objects to bifurcation.
Right.
And plaintiff objects, saying that you can't treat the bad faith case this way, that what you're doing, they have no right to present this evidence or to exclude our evidence of bad faith. So objection 1 to order 1. Order 2, sua sponte order, no objection.
After that,
No,
after that, didn't counsel say in open court, on the record, you know, it's okay to bifurcate? I'm with you here.
Yes, let me get to, so that's order 3 that we're challenging. And order 3 was after bifurcation is done, over objection. So their argument is not that we didn't preserve an objection. Their argument effectively is that we waived an objection. We waived our prior objection. That comes in order 3. Order 3 is a motion to exclude evidence of State Farm's admissions of fault. And in that opposition, and there are two oppositions really, there's one at page 239 of the appendix, and there's one at page 299 of the appendix. And in that objection, the objection to the motion to eliminate, to exclude evidence, counsel does clearly say, you cannot use bifurcation to prejudice my substantive claim of bad faith. Can't do that. Counsel does, in what they're saying is a waiver, say bifurcation may be efficient, it may have been a good thing, it may be efficient. So I think if there's any argument about waiver, the waiver could be that we waived objections on efficiency grounds and separability grounds, okay? There could be an argument over that.
Well, I thought the word appropriate was also included there.
He did.
Okay, so would you concede that the plaintiff did waive an objection to the appropriateness of bifurcation in itself?
I'm reluctant to concede waiver. I think it requires more than that. I think what counsel did, maybe inartfully, was say, we object to any further abuse of bifurcation. We object to the substantive misuse. So I would say
that's helpful, because that's how I'd understood your argument, both there and now, that you weren't saying that the judge screwed up in bifurcating it. She screwed up, according to you.
He this time, but yeah. Judge.
I'm sorry,
Judge,
it's a
yeah.
he. That the judge then erroneously acted subsequently, but that you had given up the objection to the bifurcation in itself. I mean, by saying it's appropriate.
I wish those words weren't used, all right? Can't.
Right, yeah.
But I think in context, I think in fairness, what counsel is trying to do is saying, we're not trying to re-argue what you've done already. All right, we're saying don't make it worse, and what you can never do, and we've consistently objected to in Order Addendum 1, Order Addendum 2, and now Order Addendum 3, which is a part of our appeal, you cannot use bifurcation to substantively change the claims. All right, you cannot make this a claim. This is a claim fundamentally for breach of contract and bad faith by a policyholder against her own insurer. And you cannot make this into a claim that pretends this trial is as if Ms. Giertz, the bicyclist, had sued the car's driver. And you cannot make it into, and that as if State Farm's not a party. And therefore, when he says, and we are entitled to present the evidence of what State Farm did and said in denying the claim. And you cannot make it so sterile and artificial to make it as if this were a claim where she sued the car's driver, who, by the way, unbeknownst to the jury, had already admitted fault, the insurer, had admitted fault and had paid 100% of their policy limits. So you cannot rewrite the case and recast the case into what it is not. And you cannot use the procedural mechanism bifurcation, or in this context, an evidentiary ruling, to change the substance of the case. So those are the objections that were preserved. So I would argue, Judge Bacharach, if you want to say waiver, you could argue the prior objections which were made that said it's not efficient, it's not fair, the issues aren't separable. You could argue that those were waived. I think what was consistently said in objecting to the original bifurcation and then objecting to the evidentiary argument based on that bifurcation is that bifurcation and evidence cannot be changed to change the substantive result of a claim. And that argument is, which is our fundamental argument, both for bifurcation and evidence, because they're all interrelated, I think.
And since you always memorize the record, what page is that argument made on?
The page of which?
The final kicker where you say it's preserved.
Yeah, twice. In an objection to the motion to eliminate, page 239 and 240 of the appendix. I think that's volume 1. And then a later supplement to that opposition on page 299 and 300 of the appendix, which I believe is appendix volume 2. That is where the argument is made fundamentally, which is really our fundamental point here, is that, by the way, and we point out that every other judge in the District of Colorado, including an opinion by the Chief Judge Brimmer, says you don't bifurcate these cases. It's not done, they're not separable. If you want to say we waived that argument.
Isn't that a discretion call? I mean, every judge handles their cases differently. I don't know what pressures are on the docket for this particular court. And,
True, Judge Briscoe, but I think in this court in Angela, I think it was Judge Anderson's opinion in 1993, still the leading bifurcation case federally, says bifurcation turns on experience. It's an experiential thing. And it's something that, I'm just pointing out the uniform experience of the District of Colorado in these cases, which are pretty common, as I guess we just saw from the case 3 today, that, this is not an uncommon series of cases in Colorado, or probably anywhere in this circuit. The uniform practice does not do it. But I would say that even if for efficiency grounds and separability grounds, what Angelo makes clear, and this is not a matter of discretion, it says it is an abuse of discretion, flat out, Judge Anderson wrote for the panel there. It is an abuse of discretion if it prejudices the claim. All right? Now, bifurcation and the evidentiary ruling prejudiced her ability to bring a bad faith claim that under Colorado substantive law, and it's really undisputed, although we cited an opening brief and a reply brief never mentioned in their answer brief, under the Schultz versus Geico case, under Rayer, under Pfeiffer, an insurer cannot defend a bad faith claim on a ground contrary to or not relied on in real time when it denied the benefits.
Isn't the prejudice, however, the fact that the plaintiff had pleaded a contract claim? Because for liability, either for a contract or for bad faith, for coverage, there has to be legal liability of Ms. Gordon, correct? And the only thing that was determined at the first trial was the legal liability of Ms. Gordon. And so now, and your point was strategically, then you're looking after the fact. Well, you do have to look at the evidence that is determined after the fact to determine legal liability, but that's by virtue of the fact that you had incorporated a breach of contract claim.
Well,
right?
Well, a couple of responses. An insurer, and this is what Schultz and Colorado substantive law makes clear, that an insurer can waive a defense to benefits. All right, so an element of a breach of contract claim or a bad faith claim is that the uninsured or underinsured motorist was legally liable to the plaintiff. All right, now, if an insurer in real time does not rely on that ground and never contests the fact that there is liability, as indeed the driver's insurer admitted that its insured was liable to my plaintiff, to my client, the insurer can waive that defense.
Is there a legal obligation to waive that?
A legal obligation? No, it's something.
They can, but.
And they did here. And the evidence here, the undisputed evidence is they did. The undisputed evidence is that in real time, in the year plus that this insurer, State Farm, was refusing to pay a claim, they had never alleged that she was disqualified from coverage because she bore equal or greater fault. Never alleged that. To the contrary. To the contrary, they documented originally when they consented to the other insurer paying full policy benefits, documented that the driver, not the bicyclist, the driver was 100% at fault. Then my client files a claim. They document, they conveniently shift position. They say, well, no longer 100%, but the driver has 80% liability, 80% fault. So still you're entitled to it. Then indeed, third, and the final kind of straw on this, the last straw, I guess, in terms of their relying on this, is even after this suit was filed, they never claimed that she was not entitled to coverage because of fault. They admitted that she was entitled to coverage, and they made a payment of $2,500. So they waived the right to say that the driver was less at fault than the bicyclist. So, and that's clear that they can waive that. And factually, the evidence is clear that they did waive it here. So having done that, the prejudice from bifurcation is the jury heard none of this. This was a sterile case as if she had sued the driver in a tort action. That's all the jury knew. Never heard all the conduct. So the prejudice in the severance and the prejudice and ultimately the evidentiary ruling that we objected to, no dispute that we objected that State Farm's admissions can't come in. Judge, they're not admissions because State Farm witnesses had no personal knowledge. And personal knowledge requirement, Grace United case of this court and other cases, doesn't apply to a party admission.
So your argument, as I understand it, is not the misuse of what the adjudication at the trial one is. It's just the fact that trial one was conducted without regard to the fact that the insurer had waived the legal liability of Gordon.
And ultimately, by winning on a defense that they convinced the jury on, that was 50-50 fault, they won and defeated the bad faith claim on a ground that Colorado law does not allow. That's our prejudice.
But if we hypothetically reject your argument that there was waiver as a matter of law, then there would be no argument any longer that there was a misuse of the adjudication at trial, at the first stage of the trial.
Well, it still would be, I think, Your Honor, because we have an evidentiary point that the judge precluded admissions of State Farm that by words and conduct, that the driver was more at fault than the bicyclist, my client. So there's still be the evidentiary error that there's no
Why
claim
would
of
that
waiver.
matter if there was no legal liability of Gordon, which was the result of the trial?
Because the jury found 50-50 fault, and if they had known that this was against State Farm, and State Farm admitted that there was 100% or 80% fault, there'd be
Court
evidentiary error.
correct on that ruling. That is that what the folks in the claims adjudication office were thinking about what happened at this accident is irrelevant. They weren't on the scene, they're not experts, they're just trying to do their job in a little office somewhere.
Well, that undercuts the whole notion of federal evidentiary law in terms of party admissions. Party admissions are relevant despite parties not having personal knowledge, despite them not having expertise, and they're relevant because they show a party's real-time evaluation. If I could say one, anyway, I'm out of time, I guess, so if I could have the court's grace to maybe have a minute extra, but if not, I ask it.
You have 1 minute for rebuttal.
Thank you.
Good morning, and may it please the court. My name is Brendan Powers. I represent State Farm Mutual Auto Insurance Company, the appellee in this case. This case presents an interesting conundrum in that the appellant is asking this panel to override the clear discretion of the court, where the court identified a single question of fact that is a threshold issue on which the plaintiff has the burden of proof for each of the plaintiff's claims.
But is it a threshold issue on the bad faith question?
It is absolutely absolutely a threshold issue, Judge Briscoe. If we look at...
So if you have no ability to recover under your policy, then you can't talk about bad faith.
That is absolutely true in Colorado. The substantive law in Colorado is undisputed that if you cannot establish your breach of contract claim, your entitlement to benefits, then you are not entitled to pursue bad faith claims. And when we speak in terms of bad faith claims, I want to be careful.
And the best case for that is which case?
That would be, Your Honor, there's a number of cases. I would point to Jarnigan versus Banker's Life, 824 P. 2nd 11.
Jernigan?
I think it's Jarnigan, J-A-R-N. And also Tynan's Nissan versus American Hardware.
Got it.
That is 917 P. 2nd 321.
Yeah, those are in your brief. Thank you.
Thank you, Your Honor. And also Hayden, H-Y-D-E-N versus Farmers Insurance, 20 P. 3rd 1222. Also, if we look at the statute in Colorado that speaks in terms of punishing insurance companies that delay or deny a benefit without a reasonable basis, that statute speaks specifically to a covered benefit. And I think that's essential here. In that, when counsel at trial in their motions, in responding to my motion in limine, when they speak in terms of the appropriateness of bifurcation in this particular case, they recognize the economy of it. This trial went from a 10-day trial to a 3.5-day trial. And it's because UIM, in this particular case, presented a unique set of circumstances where there is a single question of fact that is a threshold that the plaintiff must cross before the plaintiff can seek contract benefits, and certainly before the plaintiff can seek bad faith benefits. And here I think it's important to emphasize the holding in Sunahara versus State Farm, 280 P. 3rd 649. That case speaks specifically to all the issues that we're dealing with here. If as I followed the oral argument of my colleague, I think it's acknowledged now that economy and the appropriateness of bifurcation under Rule 42B is not really their concern. Their real concern is the question of the separability of these claims. The Sunihara case speaks in terms of that evidence about what the insurance claim representative's internal thinking is relevant to setting reserves, which are required by Colorado law, and is relevant to establishing settlement processes. Colorado law requires the insurance company to maintain these types of notes. They're like free-thinking notes. As I was preparing for the argument, I was thinking in terms of if one were to look at my notes before an examination, that would look very much different than the notes of my examination answer. When they speak in terms of these admissions, they skip over a critical element, and that is, these are not admissions. These are the thought process of the insurance company at the time. It's like a snapshot in time. Waiver was never argued at the district court level. It simply was not. And here's where I think it's critical to recognize.
Waiver by State Farm.
Waiver, yes, correct, Your Honor. When we speak in terms of the idea that the internal claim notes of the insurance company might have some relevance, Colorado law makes clear that that relevance pertains only to the questions of bad faith. And I'll quote from the Sunihara case. And Sunihara was specific to UIM actions, and there the Supreme Court of Colorado found that the internal notes and the internal thought process of the insurance company in addressing reserves and possible settlement strategy are not relevant to the question of liability.
But they're certainly not hearsay, right? They are admissions for purposes of hearsay.
No, I would disagree with that, Your Honor, that they are certainly hearsay. They are not, the claim representative has no personal knowledge of the accident.
That's a Rule 602 objection, not a Rule 801 objection.
Correct, but, Your Honor, and I would point to
maybe I don't know, maybe if I'm a defendant representative, maybe I don't know what I'm talking about, but if I say, well, the Ms. Gordon, was either 80% at fault or 100% at fault or not at fault, I don't know why that wouldn't be attributable to me as an admission for purposes of hearsay, even if I had no personal knowledge.
And Sunihara speaks directly to that, Your Honor, and that is the idea that evidence of liability assessments and fault assessments within the claim file are relevant in terms of measuring whether the insurance company, at the time it makes a decision, has a reasonable basis for that decision. But it clearly states, that case clearly states that that thought process and that type of note-taking is not a judicial admission. It says it 3 times in that opinion, that the note-taking is not a judicial admission because those notes exist not for purposes of assessing liability or determining liability.
Yeah, I wouldn't suggest that it was a judicial admission. I was suggesting that it was a party admission under Rule 802.
And that's what Sunihara says. It is not a party admission.
All right.
Because those notes don't exist for that purpose.
Okay.
Not only is it not reasonably calculated to lead to discovery of admissible evidence in UIM actions, in Sunihara emphasizes that notion that when we look at a bad faith claim, we look at the conduct of the insurance company. In the UIM context, there is that threshold question of the liability of the plaintiff and the tortfeasor. And there we focus on the conduct of the involved parties. And that's exactly what Judge Domenico did in this particular case. He said, I have a docket that is being overrun by COVID delays. I have the ability to take a 10-day trial and reduce it to a 3-day trial by identifying the threshold issue on which this jury must first decide liability of the uninsured motorist before we get to damages and before we get to whether there is a question of mishandling or bad faith handling by the insurance company. I think it's interesting to emphasize in the Angelo versus Armstrong case, 11F 3rd, 957, and particularly at 965, because there, in the Angelo case, that was an asbestos exposure case. And what the court identified was, rather than have an extended trial, let's address the threshold question of whether there is sufficient medical causation evidence that exposure to the asbestos caused the injuries and death that were in question. And the plaintiff in that case, made the exact same argument that's being made here, was that the court's use of Rule 42 to identify limited issues, threshold issues, that would eliminate the need for the rest of the trial. The plaintiff had argued that narrowing the issue that way, even though it was consistent with the substantive case law, narrowing the issue in that way precluded them and prejudiced their ability to develop more fully certain arguments. And on appeal, the court rejected that. One, it was not a showing of an abuse of discretion by the court. Rather, it was an illustration that if you can appropriately identify a threshold issue that will eliminate the need for the rest of the trial, that is appropriate. And this concept that there's other theories that you might want to develop is not relevant to the inquiry in terms of a reviewing court looking at whether the underlying court abused its discretion. I want to take a moment or two, too, to address this fallacy that the jury does not know who the case is against. State Farm is in the caption. State Farm is in all of the jury instructions. State Farm is used specifically. State Farm had a representative at counsel table. Counsel for the plaintiff in opening statement, Appendix Volume 2, 381, repeatedly refers to State Farm. I thought it's also interesting that the jury was explaining the case pursuant to a statement of the case that was presented by the parties and was a stipulated statement of the case. I would point to Volume 1, page 269 in the record. So what Judge Domenico is doing in terms of explaining the case to the jury, he's literally taking the very stipulated statement of the case that was presented
What does that
by the parties.
stipulation say? This is just a negligence matter?
It describes appropriately that this jury's charge, it is a lawsuit against State Farm, that the jury's charge is to determine fault in this case, and that State Farm has the burden of proving the comparative fault defense. It is, I think, to be emphasized that there is no question that the jury was properly instructed under Colorado law for the issue that the court determined, the threshold issue that the court identified as, first we have to resolve this. Plaintiff, first you have to establish the fault of an underinsured motorist, and then we get to the questions of damages, bad faith, those types of issues.
And it talked about going on to issues of contract and bad faith in the stipulated statement?
It does not say that in the stipulated statement, nor did plaintiff ask it to say so. Nor did plaintiff ever say, Judge, I think it's important in our statement of the case to emphasize that this is a breach of contract claim against State Farm. That is said, I mean, the jury does know that the contractual relationship is between plaintiff, appellant.
But they don't know about the bad faith claim.
They don't know about the bad faith claim. And Sunahara suggests that they shouldn't know about the bad faith claim. One of the elements of whether bifurcation is appropriate is prejudice to a party. There is an argument that it is prejudicial to an insurance company to allow all that bad faith evidence in front of a jury because it's distracting under 401. It confuses them as to what the substance is.
But that's the plaintiff's case, those two claims.
It's not the plaintiff's case, though, Your Honor. The plaintiff's case is 3 claims, beginning with breach of contract, and each of those claims require that before there is any duty owed by the insurance company, the plaintiff must establish that the underinsured motorist bears more than 50% of the fault. And the jury was explained that the instruction says to the jury, if you find the plaintiff 50% or more at fault, she will receive nothing. So the jury knows the stakes.
She will receive nothing from this defendant. And the defendant was the driver, not State Farm.
It does not say this defendant, Your Honor. It says the plaintiff will recover nothing, which is consistent with all of the case law in Colorado on how the comparative fault instruction is supposed to be phrased. And again, that instruction was stipulated as well.
That's usually just, that's usually plaintiff versus defendant, and we're not talking about a third party, which in this case is the insurance company. I mean, I get what you're saying.
Yep.
Yeah, on its face, that sounds right. But
And my time is almost up. I will leave you with that notion of, again, Sunihara, though, recognizes that UIM is a really unique set of circumstances wherein the insurer steps into the shoes of the tortfeasor and essentially assumes the defenses of the tortfeasor. And so it's the uniqueness of this case that I would encourage this panel to respect the discretion of the district court and affirm the district court's ruling. Thank you.
Thank you.
Mr.
Three quick
Conley, I
ones.
think you need to address the issue of whether or not you raised this waiver by State Farm in
Yes.
the district court.
Yes, Judge Murphy, I appreciate it. That was going to be my first point, and Judge Briscoe asked about what's your best case. He cited Jarnigan and Tynan's Nissan. We cite those and distinguish on page 4 of our reply brief. Those are cases where there was no coverage. No coverage. There is coverage here. Plaintiff undoubtedly had, and undeniably had UIM coverage. Question is whether she had benefit entitlement. And in terms of benefit entitlement, under the cases we rely on that they ignore, Schultz, Pfeiffer, Raher, that those may be waived. And that's what they said, and that's what we argued. We said you cannot, insurer, for defending a bad faith claim, say, deny on one ground and then justify that denial on a different ground. That's exactly what happened here. So there was waiver. We argued those cases repeatedly. And then ultimately the prejudice in this case is that under Colorado law, they cannot win a bad faith claim on a ground they did not contemporaneously assert. They avoided bad faith claims and ultimately won those claims on a ground that Colorado law does not allow, solely because of bifurcation and evidence, and we objected to that. So we ask you to reverse and give us a trial on the bad faith claims. And I thank you for the extra minute, and thank you, Your Honors.
Thank you, counsel. This matter will be submitted. Court is in recess until 9 o'clock tomorrow morning. Thank you.